Welcome to the Roberts Law Office Injury Podcast. Kentucky attorney Jeff Roberts has over 25 years of experience. He'll provide answers to your questions related to personal injury and automobile accidents, workers' compensation claims, and Social Security disability benefits. Let's join Jeff for this episode. Friends, welcome back. Jeff Roberts is in the studio today, and we're going to talk about another tool that he has in his toolbox called a structured settlement. Jeff, welcome.
Hey, Jim, how are you today?
Buddy, I'm doing great. I like this topic because a structured settlement is not something a lot of people know about, but it's one of those alternatives that you can offer to a client in terms of really protecting their interest that I think is one of those steps that are kind of over and above what you might consider.
I agree with you. In fact, most of the time when I bring the subject up to a client, it's a topic they've never heard of before, so I have to explain the process to them, what it is, and why I recommend that for them. So trying to educate people on that topic is a good idea, number one, and hopefully it's an idea that other attorneys who do what I do are using for their clients, because it can really maximize the money for the client, number one, but also protect the client as well.
And that makes a lot of sense. And so today you've got a guest in the studio, Cindy Chanley with Ringler Associates, and you're kind of the guru on structured settlements. So welcome. I'm looking forward to the conversation.
Thank you. I appreciate it. I'm looking forward to this.
Absolutely. Jeff, let's talk about a structured settlement just in general topics. Kind of what is it and when might you consider using it?
Structured settlement basically is just a general term that's used where the money is not, whenever you settle the case, the money doesn't go 100% to the client right at that time. That's the way I use the term anyway, that you structure it to where it's paid out over time to the client, or sometimes paid out in a lump sum, but later on for the client, depending on the age of the client. I try not to do a lump sum. I try to do it where it's paid out over increments over the time, and it's used in a variety of different ways. With minor children, I use it nearly exclusive or nearly all the time with minor children for a couple of reasons, which we can go into later on. Also, I use it whenever you have a large settlement. It's a very good tool to use. If you've ever studied or looked at lottery winners who's won a lot of money in lotteries, and then 10 years later, all the money's gone. With a structured settlement, you can protect the client and make sure that does not occur to them. And then there are certain situations where you have clients who have like are on SSI or other governmental benefits, that you use it to protect their ability to receive those benefits, and then use the money in the way that the government allows them to use the money in a special needs trust or Medicare set-aside type account, and those type of things that we can talk to Ms. Chanley about.
Absolutely. And Cindy, tell us a little bit about Ringler. Tell us a little bit about yourself.
Okay, well, Ringler is the largest structured settlement consulting firm in the nation.
Wow.
We probably do about close to half of all the structures that are done in the country. We're pretty successful. We are each, what a lot of people think of with Ringler is we're one big giant company. We actually are individual business owners that work with attorneys and also insurance companies from time to time to offer consulting services to our clients for the benefit of the injured party. It's always for the benefit of the injured party. And when I look at a case, that's what I want to do, is make sure that what we do, whether it's nothing or a combination of products and services, it's for the benefit of the claimant. I've been in the business a long time. I don't even want to tell you how long, but I actually started out in claims way long time ago. And I moved into the structured settlement business kind of by accident, and lived in Colorado and worked there for about 7 years. And then I moved to Louisville to run a life insurance company structured settlement business. So people like me, structured settlement consultants, were my clients at that time. And then I decided to go out on my own and run my own business, and I've been about 15 years now with Ringler. I'm also on their corporate board of directors. We have a corporation that kind of runs the business part of us and assists with marketing and other things for each of us, for the producers. But what I love the most is working with people, working with the people that are hurt and their families. That's my passion.
And Jeff, that aligns with your view on a lot of this because some of these families have gone through, whether it's a collision or a workplace injury or some other kind of catastrophic injury that has really changed life as they know it.
Yes, and that's a lot of my clients have gone through some of the worst times of their life when they come to see me, and that's one of the reasons I use Ringler when I do structured settlements. Now I exclusively call Ringler for structured settlements. I used to use others, but in my experience with Ringler, they are a company that is, my goal is to do the best for my client and maximize not only the money for the client, but also to structure and use the money in the best way for the client. And when I've reached out to Ringler on cases before, I've had them basically at times tell me, we don't think this is the best option for
That's
you,
right.
and explain to me why they didn't think it was the best option, and they were correct in that regard.
Mm-hmm.
So someone else who also has the client's best interest at heart, that's the kind of company that I want to be associating with and using to help my clients out.
And obviously, that's the goal in introducing the option of considering a structured settlement. But Jeff, I mean, help me understand this. It's not something that a client needs to do or has to do, right? I mean, it's really ultimately up to them. I mean, some people may want just give me the check. I appreciate it, and we'll try to manage it the best we can. But there are some times where you may not have a bunch of experience with financial matters, and sometimes receiving a large check from an injury settlement or a verdict can be a little daunting. It can be a little intimidating.
It can be, absolutely, and you're correct. The client is the ultimate decision maker. Whatever the client wants to do will be what ultimately occurs from that standpoint. My job at times is to educate the client, all the time pretty much, is to educate the client on what I think is the best for them, why I think that's the best for them. Sometimes bring in other individuals to talk with the client about why something may or may not be the best option for them, and give them all the information to make that determination. But once they make that determination, that is their decision, and I will abide by whatever decision they make in that regard. So.
Right, and that makes a lot of sense. I mean, ultimately, the client is in control of this, just as they were in terms of ultimately accepting a settlement offer. You're going to counsel them and say, yeah, well, that's a fair offer. Maybe we can do a little bit better if we push harder or go longer. There's all these variables that come into it, and that's one of the reasons they place so much trust in you and your experience of having done this for so long.
Correct. Yeah, and it's when you represent, in the cases I represent people on, it's not a short representation as a general rule. Very, very rarely is it a short representation. Normally, when they come into my office, it's early on after a collision or after a catastrophic work injury or something of that nature, and it's a long process. I've had clients that have been that I've been involved in their claim, and we didn't resolve their claim until 4, 5, 6 years after the injury occurred. And even some that even after we've resolved the claims, I've been involved with that client, and they come back to me for advice on different matters, even 5, 6 years after the claim has been completely resolved. I've been doing this for over 27 years now, and I've got clients that we resolved their claims in 2000 that are still coming to me at times, or calling me up on the phone and just asking for advice on how they need to deal with something going on with them medically that was involved in their workers' compensation claim or other type of claim. So it's a long-term relationship.
Right.
Ours are that way too.
Yeah.
I mean, we tend to go along for years sometimes before a case settles.
Yeah.
And but sometimes we're brought in at the very last minute when it's close to settling. And I know with Jeff as an example, with every child involved or every case involving a child, almost always a structured settlement's considered, because otherwise they have to put the money in a blocked account. And with a structure, a parent can actually plan for that child's future. They don't necessarily want to put a big, I know I wouldn't do that with my sons, a big giant lump sum when they turn 18. They want to plan for their future so that that money can last a while. Like a college fund. We could put money together that would pay semi-annually or annually for 4 or 5 years. We can even spread it out further than that. I look at cases, if it's a larger case that we can put money into other than college, is, significant events in people's lives. Maybe at 25 or 30, a big giant lump sum to help them buy a house. And even further out, I just did a case not involving a child, and it was a lawyer called and he said, well, this lady is 55 years old and she's getting a $400,000 settlement. Can you help her? And I said, well, yeah, the best thing in the world is to put some money away for her retirement. Maybe she hasn't saved enough and it's tax-free and she's got that safety and security. So she took $300,000 in cash, and $100,000 of her money is going to be deferred until she's 62 and pay for a while. So, there's different cases, different situations, and that's the best part of working with an attorney like Jeff, because he knows his clients. You know who they are, you've gotten to know them, and your information to us helps us try to figure out what would be beneficial.
Exactly. And the one thing we haven't talked about that's a benefit that Cindy can attest to there, the timing is very important, because we may have some people listening that says, well, give me all the money now and then I'll decide how I want to invest that money, and that's fine. But I strongly advise people not to do that, to make that decision before you get the money for tax reasons. And Cindy can tell us the tax reasons that are involved there. If the client gets the money and then invests the money versus structuring the settlement so that the money goes into the investment through the settlement.
Yeah, there's actually very specific rules in the federal tax code that require that a decision be made before the settlement agreement is prepared to indicate the payments that are paid. And if it's done correctly, and there is the appropriate language in the annuity, which is the product that is used for a structured settlement, a very special annuity, the interest on that annuity is tax-free to the claimant. So they may have a settlement of $150,000 and we structure it out, and they might get $75,000 extra interest depending on how we pay it out, and that's tax-free interest. But if they take the money and they want to do it later, we can't do it. It would have to go another route, and the interest would be taxable in that situation.
That's one thing that just blows me away in this.
Right.
I mean, obviously, Jeff will go and do his absolute best to maximize the value of that case, get the largest settlement or verdict possible. But once it's structured, because that interest, just like other investment accounts, ultimately, if it's in there long enough, it can actually yield more due to the value of compounding interest than it would have, had it just sat there. So it's actually bigger at the end of the day than
that's
than
even
the actual
with
reward.
low interest rates, believe it or not. Sometimes I say, a lot of attorneys will call me and say, well, what is a structured settlement earning these days? And my response is usually we don't sell interest rates. Financial planners sell interest rates. We sell safety and security.
Right.
Because a structured settlement by itself is not a product that's used to earn a lot of money. It's there to protect people from themselves sometimes, and for a parent to protect their child from themselves. Because I have 2 sons, and I'm telling you, when they were 18 years old, there's no way I could do that. I couldn't do it. And I have a granddaughter right now who was in a significant accident. She lives with me. There is an attorney that's working with her. She'll probably get a structured settlement if it's the appropriate thing, depending on the amount. But other issues that come up in a case is I like to take a 360-degree view of the claimant, the family situation, to determine if there's other issues that might come into play. For example, if the injured party is on Medicaid and is receiving something called supplemental security income.
SSI.
It's called SSI, and it's a little different than Medicare or SSDI, Social Security Disability Income. If somebody's on means-tested government benefits, those are benefits that are not earned but are given because of a person's injury, disability, and also their financial situation. Then they need their settlement protected through a series of ways. And what we will do is look at other products, not just a structured settlement, and a structured settlement might not even come into play, might not be appropriate. But there are a few other things that we look at, such as an ABLE account, which is fairly new. It's only a couple of years old, which is a product that will allow $15,000 a year to be placed in that ABLE account, and individuals have a little more freedom on how they can spend the money in the ABLE account, but there are rules. Rules meaning you have to spend it on acceptable items so that you don't lose your means-tested benefits. But it's a great little thing. But the other thing is a special needs trust, and you can use those in combination. I have cases where I've done a special needs trust that will pay into an ABLE account annually so that it meets the needs of the ABLE account, and also there's a larger amount of money in the special needs trust. And then you can even do something more interesting, which is to put a structured settlement that'll pay into the special needs trust, that'll pay into an ABLE account, and everything else. I was telling Jeff about a case earlier that a young girl, she's about 24 years old, was injured in high school. That's how long her case has taken to settle. And we did an ABLE account for her, a special needs trust, and an annuity. And the annuity is gonna, I think it was a very large case. It was $1 million annuity. But the annuity is expected over her lifetime to pay over $2 million. Wow. But it all has to go into that trust. She can't touch the money. And a lot of people, as you know, Jeff, they don't understand not being able to touch the money.
Right.
That's just hard for them to understand, which means you have to be helpful to make sure they understand what they're going to lose.
Exactly.
Right.
Yeah, that's where the attorney, one of the things the attorney should be doing in those situations is making sure they understand it. And that's where the benefit of the structures come in, though, as I mentioned. And you mentioned earlier about the when your child was 18 years old, you wouldn't have wanted them to have a large sum of money. And that's, I use that same analogy a lot to convince on a minor settlement in Kentucky, the settlement has to be approved by a judge. Mm-hmm. Even if the parents are appointed guardians for the children and they can say, yes, we want to settle for this sum of money, I still have to take that in front of a judge say, okay, but if I'm doing an annuity or a structure that's got special needs trust, ABLE accounts, and an annuity, I have to take all of that in front of the judge and explain it to the judge why I want to structure. And most of the judges now are understanding and are very fine with structuring, and in fact I've seen them suggest that to other attorneys before when they were there to settle the minor's account. But I've used that analogy and I use it to myself, and if I'd got $100,000 when I was 18 years old, I would have had a really, really sweet ride. And at 19, I wouldn't have had much of anything.
Right.
And but a sweet ride. And most of the judges, I've had a couple of the male judges I've been in front of kind of nod their head. Yeah, they would have done the same thing. So with the annuity for a minor, we're able to structure the payments, and most of them will kind of limit how I structure it. They won't let me go to age 50 with
Right.
a structure for a minor, but they will let me go to 25, sometimes 30 years old, depending on the amount of money going in, with payments made at 18, 20, 22, or every year or whatever, so that the person has college funds and funds to be able to live on. And it protects the money for the child while they mature, but it also protects the money for the child from a parent who may misuse the funds because
Right.
the parent doesn't have any access to the funds there, and that's an extremely rare occurrence. Don't get me wrong, that occurs, but it has occurred occasionally in the past, and so when you can structure that money to where the parents don't have access to it, and Cindy mentioned earlier a blocked account, and every judge requires a blocked account, which means the money goes into the bank, and the bank is not supposed to allow the money to be taken out of that account without a court order.
Right.
Unfortunately, the teller at the window may not realize that at that point in time, and the money can be taken out with the structure, as Cindy can attest to, that money cannot be touched by anybody until it gets paid out by the annuity company on the date that it's supposed to be paid out. And one thing, though, that I do have clients come up, and I think Cindy ought to touch on this a little bit, is when I talk to them about this, they say, well, what's it going to cost me
Right.
to have an annuity or a structured settlement person involved in the case?
It costs nothing. We're actually paid by the insurance company that provides the annuity, but our services are free.
Right.
So even if a structure doesn't happen, there's no payment that a client has to include and that does come up a lot. And even with the special needs trusts do have cost because they're trust.
Right.
And I mean, if you went to a bank and tried to set up a trust, first of all, they're going to make you set up a trust with a lot of money. Most of them have a minimum of around $250,000. We actually work with trust companies that will do lower amounts. I have one that'll even go to $10,000, and they some of these will do some pro bono trusts depending on the situation. I've had one or two of those because the pool. There's different kinds of special needs trust. There's pooled trust where everybody kind of is pooled together for investment purposes, but they each have their own independent individual account. So, and then we can do the other individual trust as well, but you're right about parents. I've had a few cases. I recently had to go testify in court, and I've done that quite a few times on some of the more complex cases where you do have a disabled child and the family gets benefits too, means tested benefits. That's another reason to protect the money because you don't want the family to lose their food stamps or their housing. That money's got to be set away so that we look at not just the disabled person, but the whole family because you don't want to mess them up either. But we can testify in court on a case involving a minor or an incompetent, and where we can show the judge the financial plan that was put together for the benefit of the child and the family. So if that's something that's ever needed, we can do that. It's something that the parent wouldn't have to do because, frankly, they don't understand a lot of it in enough detail for the judge to understand.
Exactly. And one thing that we've not talked about in a lot of the structures that we've talked about so far are kind of involved with a personal injury, motor vehicle accident, product liability type settlement. But your firm and you do get involved in workers' compensation cases. You can do that from an annuity if the settlement in a workers' compensation claim is a lump sum and a significant enough amount. From that standpoint, a lot of times workers' comp cases are paid out weekly already as far as the income benefits. But then from the medical side, there is a thing called a Medicare set-aside account that can be used to help take care of future medical needs for the injured worker. Can you talk to us a little bit about those?
Well, we get involved in the wage loss portion of the claim or the indemnity portion of the claim, which isn't the medical. We can get involved in that. And the kind of the nice thing about workers' comp is it's paid out periodically anyway. And with a settlement, which is allowed in Kentucky, you can give the claimant some cash up front and then maybe reduce what they get monthly and even pay it out in a different way. And we work with attorneys because there are issues with Social Security and things like that. Now, when a case settles when the medical portion of case settles, and Kentucky's really a little different than a lot of states, but you have the federal issue of considering Medicare's interest, and that's whether someone's on Medicare or not. However, Medicare, or the Centers for Medicare and Medicaid Services itself, will require, well, they don't really, there is no law saying they have to look at it, but most insurance companies indicate that if an individual qualifies under the Medicare guidelines, which would mean the entire settlement, including the indemnity, attorney fees, etc., is over $250,000, and an individual is receiving Social Security disability and expected to be on Medicare within 30 months, a Medicare set-aside allocation is an appropriate way to determine the future Medicare-related cost. Now, what I work with attorney, and then the other requirement or guideline is that if the person's on Medicare at settlement, and the case is over $25,000, and again, that includes indemnity. A Medicare set-aside allocation is essentially an analysis that's done by a company that follows the Medicare rules, that looks at the past 2 years, they look at the injury, and they look at every medical report, every prescription that's been paid in the last 2 years, and then they do a projection over the individual's lifetime to come up with a number, okay? And that number is typically paid out, the best way to pay it out is through an annuity. You can either pay the Medicare set-aside allocation in a lump sum, or you can pay it with some cash, and there's a formula for that cash. You can't play around with those numbers. And then an annual payment to replenish that account over the claimant's lifetime. Now, the big difference between Kentucky and almost every other state is the legislature, the ALJs, the judges in Kentucky require that a Medicare set-aside allocation be professionally administered. And what that means is, and it's really kind of cool if you think about it, they get a card from this administration company. It's like a medical card that you and I would have with our health insurance. And then when they go to the doctor, for the work injury, they use that card to go to the doctor and also to get their prescriptions. And then the bills go to the administrator. They figure out the appropriate amount to pay, and then they also file reports with Medicare every year. And what that does for the claimant is it keeps them from losing their Medicare, because if they don't use that Medicare set-aside allocation properly, they can lose their Medicare, and you don't want that to happen. Now, the biggest issue I talk to attorneys about, plaintiff attorneys about, is that's not settling future medical on a case, because there's another piece to it. Medicare-related medicals isn't the entire medical for a workers' comp claim. There's what's called non-Medicare-related expenses, and sometimes that can be a significant number depending on the case. If they're taking a drug that's not covered by Medicare, and it's or not, you call them different things, it can be very, very expensive if it's expected to pay out over life expectancy, or if an individual is getting help to take care of the injured person, or like a spouse is getting paid by the insurance company to help take care of their husband. That is called non-Medicare, because Medicare doesn't cover home health care. Or if they do, it's for a very short period of time. So what we do is we will go through the numbers with the attorney and sometimes sit down with the claimant, because nobody knows their health care better than the person that got hurt. And we'll go through those numbers and explain. And what we usually suggest is that the attorney ask for a copy of the Medicare set-aside allocation report from the insurance company. So I do a lot of this. That's probably why I'm talking so much, but I do a lot of the Medicare set-asides. It is something you should consider on the liability side too, but that's not as clear right now. Medicare is working on it. It's just not a clear way to handle it.
When you brought up the non-Medicare covered items in Medicare, or when resolving a medical with a Medicare set-aside account, and that can be a large number. I know in one of my cases, I can't remember how many years ago now, the person was on Lyrica, and at least the claimant's doctor, I think correctly, did not want the person on an opioid pain medication, so he put him on Lyrica. Lyrica was fairly new at that point, and Medicare did not cover Lyrica. And when I got the Medicare set-aside account, one of the things I always do is say, send me the numbers, don't just tell me what the dollar figure is. I want to see how it's broke out. And when I saw that, and then they had the Lyrica there, I was amazed at how much the Lyrica was going to cost over the lifetime of this client in that case. And it was, if I know it was 5 digits, I'm pretty comfortable it was 6 digits. That Lyrica was going to cost. It was a fairly young client that had a catastrophic injury, so those non-Medicare covered items can be extremely high at times.
Mm-hmm.
Yeah.
Sometimes that's larger than the Medicare set-aside allocation. And it's also important, I mean, there are products that can protect the claimant. If, for example, say they want a lump sum of the non-Medicare, there are some products that will help the claimant get discounts, and we have those products that are free, where they can have money taken out of their debit account. We also have access to bank accounts for individuals to have that are set up with some of these professional administration companies. A lot of people don't know. We kind of go all the way down and say, hey, you can do this and you can do that. They don't have to. When we mail out our policies, we usually send something that says, if you're interested, but you can do professional administration on the non-Medicare too. You can have 2 separate accounts. A lot of claimants want control of that money, though. They just do. Now, as far as negotiating, sometimes I can tell you an insurance company would have a hard time wanting to pay someone for Lyrica over their life expectancy. Yeah. Because it is an opioid, and, we do have this crisis in our country, so they might not offer 100% of a lifetime, and you know that. So it's a negotiation.
That case, we didn't end up settling because the non-medical costs were going to be so high. And when I had the numbers, I couldn't tell my client to take substantially less what the insurance company said was her max dollar. I said, we can't do that. Right. And so the claim settled, but the medical didn't settle, and they paid Lyric out. I don't know if we're still paying it or if they've switched him to something else at this point. So.
But that's something to look at in the future, because things do change. Like even with Lyric, I believe that the patent is changing. I think Medicare is looking at things like that. So the whole opioid thing it is an issue.
Yeah. I do. As a listener in the studio today, just kind of going through this, there's so much. Yeah, it's so complex. There are things out there that I would think the injured party or the injured party's family is not even thinking about right now.
Right.
And these things, some of them, depending on the type of case, can have long-term consequences when you make those decisions. I love the fact that, Jeff, you and the resources you bring, like Cindy and other people, are there to make this thing work a little bit easier, sometimes much easier, to the ultimate benefit of the client. And it's just another pair of eyes. It's another advisor to have involved to make sure that you are really doing your absolute best to take care of those clients.
Yes, and that's, when I go to a doctor, my family doctor that I've had for quite a while now, one of the things I like about him is when I go to him and I've got something that's not inside his wheelhouse, he will refer me to a specialist in that area. And when somebody comes to me, if they call me on divorces, I send them to somebody else because I don't do divorces at all. But even on my type of the cases that I handle, there are certain areas that I want an expert on. On the medical side, I hire medical experts all the time on structuring settlements and Medicare set-aside accounts and special needs trust and ABLE accounts. Those are outside of my wheelhouse. I hire an expert, or I bring in an expert. One good thing about Cindy is I don't have to pay Cindy.
Yay!
Everybody likes Cindy.
And the other good thing is Cindy has the exact same interest I do, and that's doing the best for my client in the case. But I bring in those experts, and I hope all the other attorneys who do what I do are doing the exact same thing, because somebody may be much more brilliant than I am. I don't think I'm brilliant at all, but I think I can do what I do and do it well. But I can't be also an expert in structured settlements and keep up to date with that, and keep up to date with what's going on in the law in regard to personal injury cases and workers' compensation cases and Social Security cases. So hiring and bringing in an expert like Cindy is a benefit to me, and it's a huge benefit to my client.
I think so. Cindy, any parting thoughts as we wrap up the episode today?
I've really enjoyed this.
Absolutely.
It's been a really good thing to do on an early Saturday morning, but it just makes me think about the passion that we both have, Jeff, and Jim too. I've known you a while. The passion that we have to take care of the claimants, the injured parties, and their families, because they have been through a hard time, most of them, and that we do what we do, and I appreciate you having some confidence in us to help you and your clients.
And friends, once again, I will have in the show notes, which is really kind of a summary of this entire discussion, I'll also have Cindy's contact information. If you have a question, obviously you can call Jeff. Jeff knows this product, but again, even Jeff reaches out from time to time to get other advice on this. So you'll be able to contact Cindy directly with questions you may have. Jeff, any parting thoughts?
Cindy, I appreciate your being here, and I appreciate the work that you've done on behalf of my clients in the past, and will be doing on behalf of them in the future.
Great. Thank you.
Thank you.
Friends, thanks for listening. I hope you found this interesting, and I hope you found it helpful. And once again, I'll definitely encourage you, if you've found yourself in an injury situation that's maybe a personal injury, a car wreck, something like that, or if it's a workplace injury, pick up the phone and call Jeff Roberts. Jeff is located down in Murray, Kentucky, but he's handled cases all across the Commonwealth. So once again, a lot of these things are complicated, and you want to have somebody that you can sit across the table with and actually feel has your best interest at heart. And Jeff, over the years that I've known you, I mean, you show up every day and you're ready to go. And I really appreciate that.
Thank you.
Friends, have a great time, and we'll see you soon. Thank you for listening to the Roberts Law Office Injury Podcast. Jeff will return in 2 weeks. Until then, he invites you to visit jeffrobertslaw.com and follow his firm on Facebook. At the Roberts Law Office, you'll find a history of small town service and big city results.